Thank you so much for having me here on the call. It's great to be back with Quira and presenting to accelerators. I gave a similar presentation, well, the same presentation back in May, and so I hope there are enough new folks on the call that it's helpful to you as I help try and go through the process or discuss the process that an attorney can play in your acquisition journey, as Andy said. So I've done a number of deals with Acquira clients, and I think that they're me very well. And I'm excited to talk to more of you today. So my let's see. My presentation is called 6 Questions When You're Buying a Business, and these are basically the 6 questions that if you come to me and you say, hey, John, I'm in the process of buying a business, I've got an LOI or I'm about to, enter into one. How do you help me? How do you as an attorney help me? These are the 6 main questions that I'm gonna ask you, or the things that we're gonna discuss on that first intake call to help me understand better where you are in your journey and how I can help you and point out some of the things that you need to be thinking about. So just first off, a little bit about me, and Andy, could you just let me know that did move to the next screen?
Yep.
Okay. So my name is John Wiest. I am the owner and sole proprietor of Wiest Business Law, PLLC. I am based out of Salt Lake City, Utah. I was born and raised here in Salt Lake City. I went to undergrad here in Utah, and then I went to Harvard for law school. Graduated in 2015. So I've been a lawyer now for 10 years. And I returned to Salt Lake immediately after law school. And I worked for the first 6 years of my career at two large international firms that had Salt Lake offices. But 4 years ago, in 2021, I left big law and started my own practice focused on M&A for small and mid-sized companies. I've done throughout my career, both when I was working at a larger firm and now working on my own, I've done dozens and dozens of deals, represented buyers and sellers in all sorts of industries, retail services, restaurants, e-commerce, kind of the whole gamut. And so and all across the country as well. So I have a broad range of experience in this space, and I'm happy to be able to share some of the insights I've learned with all of you. I would say the M&A is by far the largest part of my practice. I also do help clients, though, with other kind of general corporate law. So I can often act as an outside general counsel for folks who are running companies. If they have any other kind of corporate transactions, if they need any contracts. I've done a number of commercial real estate deals as well, and some private lending work as well. So that's just a little bit about me. And so to move on, let's talk about kind of the key stages of buying a business. And I imagine that most of you are currently in this first stage, searching and pre-diligence, where you've decided to take the leap from whatever you're currently doing to be your own boss, acquire a business and run it and help it grow. So you're searching and you're looking for a right fit, the right market. When you have found the right company and you're ready to make an offer, and then the next phase is the letter of intent phase, which Acquira I know helps you with that phase, where you set out the basic terms of your agreement with the seller. Things like purchase price, exclusivity, if there's going to be transition from the seller to the buyer, all of those things. That's the LOI phase. That's not necessarily what I'm going to talk about today. But the next 3 phases, the next 3 bullets here, kind of happen at the same time. So once you sign a letter of intent, you go into the next 3 stages. You are conducting due diligence, both financial and legal due diligence. And at the same time, you're working on getting a final purchase agreement in place between you and the seller that takes all of the terms from the LOI with a bunch more things and puts them into a final form that both parties are ready to sign. And also, in case you didn't have enough to do, you're also working most likely to line up financing for your deal. So those three things really happen simultaneously. It's a busy time for the buyer, for all parties, and especially for the buyer. And so the main thing that I help you with is the purchase agreement. I can help you with the other two aspects, kind of advisor, but the main thing that a lawyer does in this phase is the purchase agreement. And then once you kind of have the purchase agreement finalized, you've got your financing all in place, you're ready to close, then the closing date is the final step. And once you've closed, you own a business, you are off to the races. So we're going to focus in on, well, first, a question I get a lot right at the very beginning is people are like, hey, when should I hire a lawyer to help me in this process? Because a lot of times you can spend more than a year looking for a business. And the whole can take quite a while for you between when you start searching and when you actually close on a deal. So you don't necessarily need a lawyer to help you that entire time. The main times, or most of the time, you need a lawyer either right before you sign an LOI or shortly thereafter. I have helped people, I do help people with before they sign an LOI if they want to go through the terms of it. They don't necessarily need an attorney at that point, and especially acquirer is helping you with, they have a standard form of LOI, and I'm sure you're working with their folks to help you get that into a spot that works for both the buyer and the seller. There's probably a broker involved, or maybe a broker involved. You don't have to have a lawyer help you at that point. I'm happy to help if you want legal eyes on the LOI, but don't necessarily need it. So I would say that most often folks come to me shortly after they've signed an LOI, and they're in that diligence / purchase agreement / financing stage, and they're like, hey, I need a lawyer to help me with this. So when you come to me and you are like, hey, I need a lawyer, John, I've just signed this LOI, ready to get going, hit the ground running with this to get to close. Typically how you would engage with me, we would have the call that we're going to discuss, in this presentation, the questions I'm going to ask you. If you choose to engage me after that call, I would lay out, on the call, I would also lay out for you kind of the scope of the services that I provide in the deal. We would sign an engagement letter, which laid out in writing the scope of my services, and also included my fee. And once I had the engagement letter signed by both of us, and once received the fee up front as a retainer, then we would be off to the races, and I could help you with your deal. So that's typically when folks want to engage a lawyer, is often especially for acquirer accelerators, right after they sign an LOI. I also, at the same time, would recommend, very, very strongly, that you work with financial and tax advisors during the due diligence process as well. And you may have someone that's helping you with those kinds of things. If not, I'm happy to give some referrals. I'm sure Acquira has folks too, either in-house or people they can put you in contact with. But those are also key advisors during this phase of the acquisition journey, because all deals have financial tax implications. I'm not an expert on those. I know enough to be dangerous and to tell you, hey, you need to look at this, but I'm not one that can advise you on the nitty-gritty of those things. So I strongly advise you have a financial advisor as well. Okay, moving on. So in our intake call, these are the 6 questions that I'm typically going to ask you. First, is this a stock or an asset purchase? Next, who is the buyer in this deal? Third, who is the seller? I'm going to then ask you tell me about the real property involved in this deal. And then I'm going to ask you about your financing and how you're doing on that. And also I'm going to ask, what about net working capital? That's one thing that really comes up. So let's dive into these. We're probably going to spend most of our time on stock versus asset purchase, and quite a bit of time on net working capital as well. The others will get a good amount of time also. So we're going to just kind of move through these one by one and see if we can't bring some clarity to the situation. So the very first question I ask folks is, are you doing a stock or an asset purchase? You may or may not know the answer to that question right after you sign an LOI. but you need to decide it really, really quickly, in my personal opinion. So some folks, or a lot of folks, don't understand the difference between the two, and that's totally fine. That's part of my job, is to help you understand that, or to explain it to you, and hopefully in a way that you can understand and let you ask me questions. But an analogy that I like to use is, if you're doing a stock, it's kind of like let's say your target company is a store. A stock purchase is similar to like you buying the store, the building, the land underneath it, everything inside of it. And at the closing date, you're just going to get the key to the building from the current owner. You're going to walk right in. Everything's going to still be, in place and working. And you're just going to start running your business from day one, that exact same spot, just like you bought the whole thing. And so that's kind of what a stock purchase is like. If you're buying a business, it's like you're buying and the business is a building with everything inside of it. You're buying the whole building and all the stuff inside of it. An asset purchase is slightly different. So it's more like, an asset purchase is more like you're like building a new building right next to the old one, and you're buying all of the stuff in the old building and you're moving it right next door into the new building. You're going to take the sign off of the old building, put it on the new building. It's going to have, everybody's going to think, hey, this is the exact same company. You're going to have all the stuff in there. It's going to run just like it used to, but instead of you having the old building, you're going to have a new one. And the benefit of that, and we'll kind of flesh this out a little bit as we talk about the pros and cons. So what are some of the the pros of a stock purchase deal? So the main pro for a stock purchase is like, hey, it's simplicity. You are coming in, a company is either an LLC or a corporation, the target company, and you're buying all of the ownership interests in it, whether that's stock. I'm using the term stock purchase, which really only corporations have stock. LLCs technically have membership interests, but they're essentially the same thing. I'm just going to call them all stock at this point to make it a little bit easier. So in a stock purchase, you're buying all of the ownership interests. You're buying all of the stock in the company itself. So the company continues in existence as Acme Incorporated or Acme LLC, and it had owners X before. Now you are the brand new owner of Acme LLC or Acme Corporation. And it's simple because the company is just still running. It's got all the same vendors and agreements. It's got the same insurance. It's got the same leases and other contracts. You just now own this new company, or you are just the new owner of a currently running company. Now, one of the major cons of doing a stock purchase, and you'll probably have heard or will hear a lot of people in the space of talking to acquiring entrepreneurs. They'll say, hey, do an asset purchase. And the main reason they'll say that is because when you buy the stock of a company, think of it as a building. When you buy that whole building and everything inside of it, that building might be old, might have really crappy plumbing or wiring, stuff that you didn't know was wrong with it, when you're doing your due diligence. It may not manifest until later. And that's in the building analogy. For a corporation or for a company, you may have these hidden liabilities, like, let's say, taxes that weren't paid that you would then have to pay later, or there's some kind of a liability. Somebody slipped and fell in the physical space where the company is located, but they didn't bring their claim until after you bought it, and then you have to deal with it. So you're really taking a risk that there are hidden liabilities that you're going to inherit when you buy the stock of the company, when you buy the company itself. There are ways to mitigate that, of course, and we'll do, the purchase agreement will have mitigation clauses in there, requiring the sellers to indemnify you if something like that happens. But it's a lot of people just don't even want to deal with that. They're just like, I want a brand new building that I know everything is up, totally new and clean with it. I just want to move all the stuff from the old building into the new building. And one other factor is that that's one other con for a stock purchase is that as the buyer, you may get less favorable tax treatment, because if you come in as the new owner of an already existing company, it may have assets that have already been fully depreciated, things like that, that you can't get any, depreciate assets any further after you buy it. And so that's something that a lot of folks want to avoid as well. So that's kind of the cons of a stock purchase. And again, this is like a high level overview, but those are the main things. And let's see, we had a question here. Let's see.
Yeah, I got a question for you, John.
Yeah.
You said that you can put protections for yourself in the APA if you do a stock purchase.
Yeah.
I don't really know what to ask. I just want to learn more about that. Like, how effective are they? What's the recourse in the case that something does come up? Specifically in terms of like the liabilities.
Yeah. Sorry, go ahead. Keep going.
Well, I was just gonna say, like, I kind of have an idea, but like, I imagine it's just a pain in the neck to like have to go back to the seller and discuss those things or take them to court when something's come to you. And maybe that's why people would just rather do the asset agreement and like not even worry about drafting those representations and warranties into the APA.
So
Right.
So you're right. So the way that it's done in the APA is that the seller will make a whole bunch of representations and warranties about the company, including things like, hey, we don't know of any hidden liabilities, and hey, we've paid all of our taxes. There's, you should, hey buyer, you're not going to have to pay any back taxes when you buy our company. So the APA they're going to swear up and down that their company is clean and ready to be sold in the APA. And so after a closing, if it turns out those things aren't true, then you can go to the seller and say, hey, you made these reps and warranties in the APA. Turns out they weren't true. And the APA has a section saying, if those things turn out to not be true, then you have to indemnify us for any costs or any liability, that we incur as a result. Now, you're right. That's kind of a painful process, right? You have to go to them and ask them to indemnify you. If they don't comply, then you have to sue them. And that's just not fun for anybody. It takes a long time. It takes mental and emotional energy, and not to mention money. So yeah, those protections are in there, and they're going to be in there even in an APA, even in an asset purchase agreement versus a stock purchase agreement. They're all going to have reps and warranties like that. But those are that's the recovery that you can expect, and it's not great. So that's why folks will just say, hey, I don't want to worry about that at all. I'll do an asset purchase.
Okay.
So,
Second follow-up question to that is, how much additional work is it to put those into a stock purchase agreement rather than an asset purchase agreement? In terms of like, how much additional money would it cost to have that lawyered out during?
It's standard in both.
During that process.
It's not standard in both of them. Yeah.
Okay. And most of it's boilerplate.
Yeah, it's mostly boilerplate. Sometimes some of the finer points get negotiated depending on the business, and like, hey, this really doesn't apply to our business because of X, Y, and Z reasons. But for the most part, sellers don't balk too much at making those reps and warranties. That's a very broad statement. But yeah, every asset purchase agreement will have a lot of reps and warranties from the seller. That's part of my job. I wouldn't be doing it well if I didn't include all the reasonable ones in there. So
okay.
So thank you. That was a great question. Because yeah, a lot of folks just don't even want to deal with that. That's why they do an asset purchase. And so yeah, going on to asset purchases, that's the pro. You don't have any liabilities. You got a brand new building. You don't have to worry about crappy plumbing from the old one. You don't have to worry about back taxes, any of that stuff. And also you can get some more favorable tax treatment. You likely are able to get so when you buy the assets, you're buying all the stuff inside of the store, moving it into the new store. You then have a new basis, a new tax basis in those assets for however much you paid for it, for them. And the purchase agreement will have an allocation of what, you have an overall purchase price, and then you'll have a section that allocates that purchase price more specifically towards certain assets and different categories of assets. And you can then probably depreciate those assets over time and maybe save some money on your taxes. So that's another reason. And again, I'm not an expert. Talk to your CPA or financial advisor about that. But that's generally how that works in an asset purchase. One of the cons for doing an asset purchase are that you have to transfer the assets, which it can be a headache. It cannot be that big of a deal if there's a lot of physical assets. Like if you had a lot of the target company has a lot of trucks or something, and you need to transfer the titles. And I mean, it's kind of a headache, but it may be worth it. It's probably worth it, but it may not be worth it. You also have to take into consideration that when you are doing an asset purchase and you're building that brand new building right next door, you have to build that building and you have to get it insured and you have to do all the things when you start up a business. And I've had some clients say to me, hey, I would rather do a stock purchase and just have all this stuff already in place than me having to go out and get insurance and get all of this different stuff for a new company that doesn't have, a history that I'm buying these assets to put into this new company. And so it really just depends on kind of what your preference is. I've done both. And so you hear a lot, do asset purchase. And I do think from a liability standpoint, that is the best. But stock purchases work as well. And I will tell you that probably the number one reason that buyers want to do a stock purchase is because it can be difficult to transfer contracts from the seller to the buyer in an asset purchase. So what I mean by that is a lot of times the seller, the target company, one of its main assets may be its contracts with its customers. And those contracts may have clauses in them that say, hey, Acme LLC cannot assign this contract to somebody else without getting consent of the customer. And so if that's one of the main assets that the target company has is a bunch of contracts, and if they have clauses in them that say those contracts cannot be assigned without, either they can't be assigned at all or they can't be assigned without the consent of the client, of the customer, then you may just want to do a stock purchase and not have to worry about trying to assign all of those contracts to a new entity. And I've seen this a lot I had a client who was buying a company that its main customer was government entities. It was providing services to state and federal and local government entities. And most government contracts where the government is the customer have anti-assignment clauses in them that say you cannot assign this contract to somebody else. So in that instance, the client was like, hey, these contracts are the most valuable thing that I'm buying. It would be such a pain to try and move them. I don't even know if I'd be successful in moving them to a new company. So I just am going to do a stock purchase just to make sure that those assets, those contracts stay in place. We don't even really have to probably don't have to tell the customer that the new owner is in place. And so that made sense for that client of mine in that deal. So those are kind of the main, there's pros and cons on both sides. So I've seen both, I've done both, and it really just depends on the situation that you're in. But that's the first question that I'm going to ask you. Okay, moving on to question number 2. All right, so who is the buyer in this situation? And this really is a discussion about the type of entity that you are going to want to set up, or probably going to want to set up to be the buyer in your deal. So there's 3 options. There's one, you could either buy the assets as an individual in your own name. I, John Wiest, am buying the assets of Acme LLC, or buying the stock of Acme Incorporated. You could also, but more frequently, people will either set up, or maybe they already have an LLC or a corporation that is going to act as the buyer in the deal. So this is also a really important issue that I want to just like to educate people about. So the only time that I would advise, or that I think it would be even a good idea at all, for an individual to be the buyer in the deal is if you're going to do a stock purchase. So if I wanted to buy Acme Incorporated, I would feel comfortable most likely buying 100% of the stock in Acme Incorporated in my own name. John Wiest holds that stock personally, because I still have the protection of Acme LLC, or Acme Incorporated, the company, protecting me from personal liability. So I would never, so in a stock purchase deal, you can do that. But if you're doing an asset purchase, I would never recommend that an individual buy the assets of a company. I, John Wiest, would never buy all the assets of Acme LLC and then hold, the office building and the trucks and the contracts and all those things in my personal name, because that would not offer me any type of entity protection from personal liability. So, so I don't, individual purchases really only for stock purchases. I think that the most common type of buyer though is an LLC, and that's for good reason. So an LLC is it's a business entity organized under your state's law. It's called a limited liability company. It literally limits your liability. And it's different from a corporation in that it's more difficult to transfer or to sell the ownership interest in an LLC. And it works well for smaller companies or closely held companies where you don't want to make it easy for somebody to buy part of your company. So LLCs work really well they work for stock purchases. An LLC can buy the stock of a corporation and hold it. But if the target company in a stock purchase has chosen to be taxed as an S corp, that complicates things. And we'll talk a little bit about S corp status in just a second. So let's put a pin in that, but just know that there's some complications there. But a LLC is a great option for asset purchases. So if you want to set up an LLC to buy all the assets of either Acme Incorporated or Acme LLC, it's great to hold them in an LLC, especially if it's just you as the member or you and like one other, friend as a partner or a spouse or something like that, and you're the only owners of the LLC that is the buyer in the deal. It's also a great option for real property. I would say most business real property is held in LLCs, and often a separate LLC from the company that is running on the, in the office space itself or in the location itself. And we'll talk about real property in a minute. Corporations are also another business entity. I'm sure you all have heard of them. And there are two main types. There's a C corp, which is the default type of corporation. And a C corp is, you organize it with the Secretary of State or wherever or in your state, and it has so many shares of stock that it can issue to its owners. And stock in a corporation is relatively easy to buy and to sell. You don't want to violate securities laws, and you can't just like go into the open market and be like, hey, anybody can buy this. But you can do private transactions with your stock of your corporation. So that's a pro if you want that. If you want it to be easy to, you're like, hey, I want to bring on investors pretty quickly, and I just want to give them, 10% of the stock or whatever, and not make it super complicated. A corporation is a good way to do that. It's easier to do that with a corporation than with an LLC. It's not impossible to do with an LLC, but corporations are just a little simpler. But the bad thing about a C corp is that it gets taxed twice. So the corporation itself has to pay taxes, and then all of its shareholders also have to pay taxes on the money that they get from the corporation. An LLC is not that way. An LLC does not pay taxes itself. The members of the LLC pay taxes on the money they get from the LLC, but the LLC itself does not pay any taxes at the entity level. So C corps pay taxes twice. That's kind of the bad thing. S corps are a different kind of corporation that gets the favorable tax treatment of an LLC in that the S corp does not pay taxes at the corporate level. Only the shareholders pay taxes at the personal level from the money they get from the S corp, which is, sounds really, really wonderful. But there's a lot of restrictions on who can be a shareholder of an S corp. And so it's really limited to individuals, certain kinds of trusts or estates, and single member LLCs, meaning an LLC that has only one member and is essentially disregarded as an entity. And it's if you have, also you cannot, so no partnerships, no corporations, and no non-resident aliens can be shareholders of an S corp. If you're an S corp and you sell some of your stock to a partnership or to another corporation, your S corp status immediately gets eliminated by the IRS. You also cannot have more than 100 shareholders. So if you're planning to like sell to hundreds of people for small shares of stock, then you will lose your S corp status. And you can only have one class of stocks. You can't have like a bunch of class A, class B, and some are preferred and some are non-voting. None of that works in an S corp. So I've had some like CPAs and other attorneys be like, man, I don't know why anyone would choose an S corp. I think that they're fine. for small, closely held companies that want a corporate structure, a corporation structure for whatever reason, but they want the favorable tax treatment of an LLC. I think that's fine. But I also think that doing an LLC from the very beginning is a pretty good option. So anyway, I would say that for most of the Acquira accelerators that I've worked with, they set up an LLC to be the buyer for their asset purchases. And they'll often, if they're doing a stock purchase, either buy them as an individual or as a single member LLC for the stock purchase. So that's kind of, I'm going to be like, hey, tell me about this. And you may not have set up this LLC or corporation right after you sign your LOI. That's totally fine. You have time to do it before closing, but it's something you need to think about pretty quickly. Okay. So then I'm going to ask you, who's the seller? So this relates to what we've been talking about, asset versus stock and S corps and things like that. So in a stock purchase, the seller is likely an individual or maybe a trust that is selling all of the stock in the target. So, Acme Incorporated has been, running for 40 years. Let's say it's like a roofing company or something, and it started by Jane Doe. She owns 100% of the stock, or she and her husband or somebody else, they own all of the stock in their own name, or maybe they put it into a family trust or something like that. So in those instances, Jane Doe and her husband, or the trust that they've put their stock into, is going to be the seller in the deal. Now this, it doesn't matter too much, but you do want to know, is the target currently, so if you're buying the target itself, you're doing a stock deal, you're going to take over the target as it's currently constituted, as it's currently taxed. And if it's currently being taxed as an S corp, and one thing I should have mentioned on the last slide. So LLCs, regarding their tax status, when their default tax status is that if an LLC has more than one member, so if it has one member, an LLC is called a disregarded entity, meaning that in the eyes of the IRS, it basically doesn't exist, and you as the owner of the membership interest pay taxes yourself. If it has two or more members, then the LLC gets taxed as a partnership, and it's by default. And that still means that the LLC does not pay taxes itself, but each of the members are considered partners, and they have to pay partnership taxes. Some people don't like that. Partnership taxation is kind of weird. And so a lot of LLCs will choose to be taxed as an S corp, which means they still get that pass-through tax status of an S corp. And so the LLC doesn't pay any taxes. They don't have to deal with kind of some of the weird parts of partnership law, or excuse me, partnership tax law. So a lot of LLCs choose to be taxed as an S corp. Like my firm, I'm the only member of it, and it is an LLC that is taxed as an S corp because it's because my structure is simple enough for me to do that, and it provides some other tax benefits related to distributions and things that a CPA can explain much better. But so if you are looking at looking to buy a target, and the target is currently taxed as an S corp, then the buyer, you as the buyer, can only be an individual or a single member LLC. So you can't form an LLC, buyer LLC between you and your spouse, or you and two partners, to buy the stock of an S corp. If you did that, the target would lose its S corp status, which is probably relatively valuable to you. And so you don't want to do that. You need to figure out how is the target being taxed, and figure out how you want to structure your buyer entity accordingly. So in an asset deal, the seller is the target itself. It's not the owners of the target, it's the target. So Acme LLC in an asset purchase is the seller. Acme LLC is selling to buyer LLC all of its assets. It's pretty straightforward, but in a stock purchase, you need to pay attention to that S corp status if that applies. Okay. So next, we're going to talk about real property. So I would say that for a lot of the Acquira clients that I've had, they are buying. They're buying at a company that operates in a physical location. It's not like a totally remote space. It's usually typically like a services company, something like that has like maybe a factory or a storefront or whatever. And so that operates in a physical location, as opposed to like, say, like an e-commerce company that all the employees work remotely from home. They don't have like a central office that they lease or that they own. So there's going to be a real property aspect to your deal. And you need to figure out, and this is probably addressed somewhat in your LOI, you need to figure out what you're going to do with that real property. So you need to first know who like currently owns the real property where the target operates. So it's often the principal or the current owner of the target company. Say Jade Doe owns Acme LLC, but she also owns and it's some kind of a fabricating company that makes something. It operates out of a factory, but she may also own the factory itself and the land underneath it through a different LLC. Either it would probably, or it most likely be through a different LLC. Let's call it Acme Real Estate LLC. And so that's one type of structure that can be in place. The other is that Acme LLC operates in a factory that is owned by a completely unrelated third-party landlord. Some commercial landlord that owns a bunch of property, or maybe just owns one property, but they're not at all involved in the running of the target company. They just own the land, have been getting paid, been receiving rent for it for however many years. So you have, depending on who owns the real property, you have a number of options. If the target principal owns it, then you can either buy the property from that person, or you can lease it. So I had one deal recently where my client, the buyer, was a couple that they were buying. Target company was a flooring company. So the flooring company operated out of a space that was owned by an LLC. So the flooring company was an LLC, and then there was another LLC that held the real property where the flooring company operated. Both of those LLCs were owned by the same people. So my clients, they wanted to buy both flooring company LLC and they wanted to buy the real estate underneath. So they set up a buyer business LLC to buy the assets of the target. They did an asset deal in this case. And they set up a separate buyer real estate LLC to buy the real property. And it was, totally fine to do that. We did so there were two separate buyer entities, and there were two separate purchase agreements, which were contingent on each other. Each of them said, hey, the closing of the purchase of the business is contingent on the closing of the purchase of the real estate, and vice versa. But totally fine to do that, not a big deal at all. The other option, if you don't want to buy a building, and there could be a lot of reasons why you don't want to, and maybe you just don't want to pay for it, maybe you don't plan to stay there for a long time, you can lease the real property from the current owner. So this means that if the real property is owned by the target principal, that means you're going to have to deal with that person for as long as you lease from them. So if you're coming in and buying a target company and you're like, hey, the person who runs this company or owns this company, they're fine, but like I can do a lot better, and I don't necessarily want to keep them around for a long time, or I don't enjoy working or dealing with them a whole lot. You may not want to have that person as your landlord for a long time, but chances are they may be just a totally fine landlord as long as you pay them rent and don't destroy their property. They don't care what you do. So those are kind of individualized decisions based on the deal. So if a third party owns the property though, then you really need to start talking to that landlord pretty quickly about either assuming the current lease or entering into a completely new lease with the landlord. The benefit of assuming a current lease is that the terms of the lease probably won't change very much. The landlord may just be like, oh yeah, I don't care, you come in as the new tenant or as the tenant under the current lease, that's totally fine. You step in, the lease has a certain term, you're in the middle of that term, it has whatever other parts of the lease agreement, and they don't change all that much. But that may not be great because maybe it's like a really old lease that's been amended a whole bunch of times and it's a little bit confusing what it actually says, and maybe it's not super favorable to you as the tenant. So you may not want to take on the new lease, or excuse me, the old lease. And also the landlord probably, they may not want to just let you slide into the old lease. They're probably going to be like, oh, hey, here's a new person that wants that needs my real property. They want to lease it from me. Oh, this is an opportunity for me to renegotiate the lease, maybe for some higher rent, maybe for some more favorable terms. And so it really is a negotiation with the landlord. And I've seen a whole variety. Some landlords are like really take the opportunity to try and make things a lot better for themselves, and others are just like, I don't care that much as long as you pay me rent and take care of the property. I will say that it's typically not a huge deal. Like getting either assuming the old lease or getting a new lease is not a huge deal. Landlords want to rent their spaces, and especially if they're like a third party that's not involved at all, they're just gonna be like, yeah, great, enter into a new lease for another 5 years or whatever it is. I will say that the SBA, if you're gonna get an SBA loan to finance your purchase, they will require that the term of your whatever lease you have for the real property, they require that it be at least as long as the loan that they're giving you, which is maybe 7 years, 10 years. They're going to say they want assurance that you're going to be able to continue operating in the location where the target currently operates for as long as you owe them money. And so that's another thing. If the old lease isn't for as long as it needs to be to satisfy the SBA requirements, then you'll probably need to get into a new lease with the old landlord. But that's, again, I don't think that that this is like such a huge part of the deal. I don't see a lot of difficulties with getting a new lease as part of any given deal in my experience. And so but it is something you need to start working on relatively quickly after you sign the LOI. Okay. We're getting closer. So I'm going to ask you about your financing, and I'm going to, and I'm sure that this is something that Acquire has been helping you with as well by the time you get to an LOI. So I will say that in most of the deals in the space that I work in, the size of deals that I work on, the deal is typically financed by a combination of bank, seller, and buyer financing. So you go to a bank and let's say you want to do an SBA loan. They're going to require that you put in a certain amount of money up front. They're also going to probably require that the seller carry some of the purchase price as a note. They're going to, maybe 10%. They're going to want the seller to and that, I think their reasoning, and I'm not speaking for the SBA, I don't work for them, but their reasoning, I think, is that the seller needs to be incentivized to help the buyer be successful in owning the business going forward. And so if you as the buyer owe the seller money going forward, 10% of the loan or 10% of the total purchase price, then they're going to not tank your company right before they sell it to you or do something else stupid like that. So the SBA in theory wants the seller to have some skin in the game. So they require that the seller finance a part of the purchase price, which is fine. I don't think it makes, for you as a seller, it's probably perfectly reasonable terms. And so you owe money to the bank, and then you later, probably after a couple of years, have to start making payments to the seller. So security, and this is one thing that has come up in a number of deals that I've done recently, is the question of security for the seller's loan. So the bank, being a bank, is going to take security in everything. They're going to, especially with an SBA loan, they're going to take a security interest in either the stock or all of the assets of the target company that you are buying. They're going to require you as an individual to sign a guarantee that says, hey, if I don't, if my company, if my buyer LLC or corporation doesn't repay the bank, then I personally will repay the bank. They're going to probably take a lien on if you have a house and your personal assets. They're going to take a trust deed or a mortgage on those. That's all very standard for a bank. I represented banks for a number of years earlier in my career, and that's what they do, and it's expected. Now, for the seller, if the seller is financing part of the deal, 10% note or something like that, it may not be clear in the LOI whether that loan is secured or not. And as someone who has represented lenders throughout my career, I would I think a seller would be totally crazy to lend you money without having it secured, without securing it by a lien on your assets or something like that, or a personal guarantee. I just think that's crazy for anybody to make an unsecured loan. But some sellers are not that sophisticated, and sometimes they have attorneys who are not super sophisticated in that, and they don't ask for that. And if I'm representing you as the buyer / borrower, I'm certainly not going to offer it in the first instance and be like, hey, don't you want to take a security interest in, the assets or whatever? If they don't ask for it up front, I'm not going to there's no reason, there's no requirement that the loan be secured. So I'm not going to offer that in the first instance. But I have had situations where the seller made an unsecured loan. I was like, wow, I can't believe that happened. Good for my client. But that doesn't happen most of the time, and I wouldn't expect it to happen. So one thing you need to recognize as the buyer is that you're going to probably have to give some security to the seller to secure the seller note. And I've had clients that had a variety of reactions to this. Some clients of mine have been like, absolutely not. I will absolutely not give a security interest in my company, but I will give a personal guarantee on the loan. And other clients are like, no, I will not give a personal guarantee, but I will give a security interest in the assets. And others are like, oh yeah, they can have both. Like they can, I'll give a security interest in the assets and a personal guarantee. If something bad happens and I go bankrupt, the seller can get in line behind all of my other creditors and whatever. Just as, it's not worth fighting about. So I do like to talk to my clients up front and just be like, hey, this is something that you should probably expect. I don't think that not wanting to give security for a seller note, I don't think that's a hill that you want to die on. That being said, there are circumstances where maybe it is something that you don't want to do based on, maybe the seller is kind of weird, or I don't know. I can imagine a world where you would not want to do that. But I would say that most of the time you should probably expect to give some security for the seller note. That's just something that I've seen come up a number of times and wanted to kind of flag for you guys. But regardless, if you give security for the seller, their security interest is going to be subordinate to the bank's no matter what. The bank is always going to be the first person in line. If you stop paying your debts, the bank is going to get first in line to ask you to repay, and they're going to have the first crack at your assets to satisfy unpaid debt. And the seller really just needs to understand that. That's just how it is. Most sellers don't have a problem with that. And if they did, I would tell them, too bad. Like, that's how it works. So, but those are just some kind of thoughts about financing, things that I like to flag for people right from the very beginning. And as I'm working with my clients throughout the process, I'm talking to them like, hey, where are you with the bank? And I'm in communication with the bank often, and the bank, as you get closer to closing, the bank is going to have a whole closing checklist where they're going to, for the buyer, saying, hey, these are all of the things you need to get to the bank so that our underwriters can look through everything, make sure that you're like a worthy, you're credit worthy, or you're not a terrible credit risk, that we actually are going to fund your loan at the end of the day. And that is, I would say that of what the time that I spend on a deal, that is a significant portion. And it is probably more than half of the time that I spend on a deal is helping my clients comply with the bank's requirements to get to closing. And that's just kind of how it works when you're borrowing money from somebody else. And I'm happy to help my clients kind of walk through that process. All right. Last thing. So, and I said at the beginning we were going to talk about this a lot, and I spent too much time talking about all these other things, but we'll get through this as quickly as we can. So net working capital, I would say that when I'm working on a purchase agreement for a deal, the issue of net working capital is the number one negotiated issue. Most parts of a purchase agreement are not terribly complicated or controversial. That's just like, this is standard stuff that we put in a purchase agreement. Both sides recognize that. But deciding what to do about net working capital is something that is typically heavily negotiated by both sides. So it's usually not addressed in an LOI, and I know that in an acquirer's form LOI, it says the parties will negotiate net working capital as they're drafting the purchase agreement, and that's fine. It would be great if you could have have decided on how you're going to do networking capital right up front, but you probably can't figure that out until you get into due diligence after the LOI is signed. So what is networking capital? In brief, what it is the amount of cash or cash equivalents that you as the buyer need to have the day you take over the company to help you run that company until you are, selling and collecting, accounts receivable, things like that. So you are going to have, maybe a payroll for your employees. Maybe you have, all these other things that you have to pay to keep your business running. If you don't have any cash on day one, if the seller has stripped the company of all of its cash and you don't have another source of cash to run the company, you're going to fail immediately. So typically what I see happen is, is that the seller will leave some amount of cash in the business. This is pretty common. And net working capital is generically defined as all assets of the company minus all of its liabilities. But it can be, it usually is a mixture of like cash in a bank account, accounts receivable, and inventory. So cash obviously is cash. You can spend it however, immediately. Accounts receivable are in a lot of companies almost as good as cash. So depending on how rapid, like if a company's AR is paid off really rapidly, like you within 30 days or something of when an invoice is sent out, you get paid by the customer, then AR is almost as good as cash. You do have to collect it, and so there's that aspect of it, but it's almost as good as cash. The point is that you need to have liquidity while you're getting going with the running of the company. And I'm going to guess that the bank is going to require you to have this. So you need to talk to based on the type of company that you're buying, what services or products it sells, what its collection methods are, what its typical accounts receivable payment structure is. You need to figure out with the seller like what is reasonable, a reasonable amount of cash or cash equivalents for you to have on the day that you close and take over the company to get it running and to make it a success. So, yeah, one way to do that is for the seller to leave some amount of cash or cash equivalents in the company. Another way to do that, and some, it's hard mentally for a lot of sellers. It's very difficult for you to say, hey, I need you to leave me, $100,000 in the bank account. They're like, that's $100,000 that I could be taking with me, and et cetera, et cetera. And but like, if they don't, then you don't want to buy their company and they don't get the rest of their money, right? So it's like something that sellers need to understand as well. And if sellers are having a hard time with that, I can usually work with their attorneys because their attorneys will understand it, and maybe their attorney can talk to them about it. But that's something that you as a buyer in your negotiations with the seller also need to understand. And don't be surprised if they have a difficult time with it, especially if they're less sophisticated in these kinds of things. But it's pretty typical for the seller to leave some amount of cash or cash equivalents in the company. Your other option is to get a line of credit from a lender. This is one of the pros of this is it's relatively simple, and it doesn't require you to negotiate with the seller on having them leave some money in the company. And a lot of lenders, I think, are willing to do this. The con is that you have to pay interest on it. But in reality, if you get net working capital from the seller, you're really paying for it through the purchase price. Like the purchase price, that's maybe goes up because of that, and that purchase price is being funded by the bank, which you're still paying interest on your loan to the bank. So it's kind of washes out in my opinion, but the bank may not want to give you just a straight up line of credit without any cash in the company at closing. So they may require you to have net working capital regardless. But those are kind of two options. And maybe you come in and you like have some cash that you're bringing in as a buyer that you can use as net working capital. But that was a really quick overview of a pretty complicated issue. So I'd be happy to talk to any of you about that in more detail because we're almost at the end of our time here. But that's a really big thing that you need to think about pretty quickly and start working on right after you get your LOI signed. Okay. So I know we only have like 2 minutes left, but I just wanted to ask if anybody had any questions. Please let me know. I'm happy to answer questions now. And I'm also happy to have a call with any of you Here's my contact information, and I think Andy's going to send this out as well. Happy to schedule a call with any of you, 15 minutes to chat about your deal, and any thoughts that you may, or questions you may have for me. Be happy to answer them.
I have another question, John.
Yeah, go ahead, Ben.
So in the acquirer workshop, they mentioned neutral counsel. I brought this up in a conversation the other day that I was having with a lawyer, and he was like, "I've never heard of neutral counsel before." Have you done neutral counsel? Because the way that Hayden talks about it is that it can save a lot of money and time and effort in negotiating if you just have one person kind of putting a deal together for both sides.
So, it's funny you asked that, because I had another friend of mine ask me about that just last week, and I had never heard of that. I don't know how that works. To me, it sounds illegal and unethical, but it sounds like it's something that people are doing. So I need to do more research on that. I personally, I don't think it sounds like a great idea. I think both parties need a lawyer to represent their interests, but it sounds like something that people are doing that I've not heard of before, and would want to do more research on before I talk any more specifically about it.
Okay.
So.
And then on the networking capital thing,
yeah,
I'm confronting this in an offer that I have submitted. They want a number in the LOI, like a hard number, like,
yeah.
And I don't know what to commit to, because it could be up here, it could be down there. I don't have access to monthly cash flow statements, so like,
So I think in that situation, yeah, that's the problem. You don't know how much money you need to run the company without looking at their financials to see how much money they've been using to run the company, right?
Yeah, I have like end of year snapshots with APAR, but like that's all I have. I don't have month-to-month fluctuations.
So my advice is, if they want to figure that out before the LOI, then you ask them, hey, I need much more information about your financials before I can commit to that number, or to commit to any number. And so that, if they're willing to share that with you, they'll probably ask you to sign like an NDA or something like that. It's not a big deal. But you also may not want to do that much work. I don't know how interested you are in this company, but you may not want to put all that effort into figuring that out before you even have an LOI where that gives you exclusivity, right, to their. And so that's something, if they're like insisting on that, say, hey, either allow me to make this decision based on the facts, based on the numbers, or like we need to talk about it after we've signed an LOI and I know that you're not shopping your company to anybody else while I do due diligence.
That's a good perspective.
So,
yeah. Let me think about that. I like that, because it's three technicians. They're mold makers, right? They manufacture stuff. They're not business people. They had another offer, and they put like a peg rate formula in the LOI they sent, and apparently they got freaked out. And so the broker was like, just put a number in there. They countered my offer by saying, hey, like cut the working capital in half. And I was like, I don't know, man. That's just what I thought based on like the numbers that I ran. Like, I want a third party to validate this, because it could be double, it could be half. Like, I don't know. So
yeah, I think you're definitely, it's more than reasonable to be like, hey guys, I need more information to make a decision on this.
Yeah.
So
okay. Thank you.
Yeah, absolutely. Any other questions?
Thank you for the time today, John. Really appreciate it. These are always helpful.
Yeah.
Yeah, actually, I want to thank you, John, for sharing your expertise and experience with us, and even answering questions. That's going to be really helpful to our accelerators.
Well, thank you for having me. I always love talking to acquirer folks, and please don't hesitate to reach out if you have any more questions or I can help in any way.
Totally. Thanks again, John, and thanks everyone.
Thanks everybody.
Thanks very much.
Have a great Monday. Bye-bye.